Good morning. Welcome back. Yesterday, Herman Grech's play, They Blew Her Up, and the conversation we had with Herman and Matthew set the tone for our conversations that followed. We all, I think, paid closer attention on scrapping the question mark at the end of the title of this conference. We had two very insightful panel discussions moderated by Carmen and Andres, and a comprehensive perspective on the challenges of digital and physical safety, SLAPs, exiled journalists, the need for more institutional support and coordination. We had two unique testimonies by Inga and Olga, supported by our discussions with Sabine, Tom, Sarah, Nicola, Carlos, Olga, Morgans, Isabel. Now we've come to our third panel, which is on the legal limitations of freedom of expression in times of conflict and war. And standing in for Chan Yekin Su is Jody, the president of the CPJ, and I yield the floor to her.
Not working? Oh, yes. Good morning, everyone. As you can see, I am not Jan. He's unwell. So I'm going to pretend to be an international human rights lawyer for this morning to discuss a topic that I think is really key and which a lot of the existing literature doesn't necessarily give us a lot of guidance. So I'm really looking forward to this panel because I think it's an area where we need to develop more jurisprudence, we need to develop more information so that we in the NGO community, but also in the legal community and the regulatory community, can understand better how to balance competing rights and freedoms during times of conflict and war. So we're going to begin with a keynote from Martins Mitz, who's a judge of the European Court of Human Rights. Martins.
Cienītās dāmas, godātie kungi, labrīt! Ņemot vērā konferences starptautisko raksturu, es runāšu angļu valodā. Ladies and gentlemen, good morning. I'm afraid I will not be able to give you recite, because after all, everything is about the balancing, but I will try to give insights into some of the aspects of the topic, which is at the discussion today, on the basis of some of the cases that have been decided in the European Court of Human Rights. So, freedom of expression ensures pluralism of opinions, which is an essential precondition for the functioning of democracy. At this moment, it is important to take note of the impact that freedom of expression exerts in situations of emergency, such as internal conflict or war. On the one hand, an accurate, reliable information is crucial for the public to form opinions in situations of crisis, both inside the country and in the rest of the world. It is also important for registering national and international crimes. On the other hand, distorted, made-up information or skillfully crafted alternative reality all have equally strong impact on the public, and it is more difficult to contest such information when access to it is limited. Article 10 of the European Convention of Human Rights, which guarantees freedom of expression, is not listed among the rights from which states may not derogate during public emergencies under Article 15 of the Convention. Notwithstanding this, there are not many instances when states have formally derogated from their obligations under Article 10 in situations of public emergencies. A recent example includes public emergency declared to deal with large-scale post-election protests in Armenia. In 2021, in the case Dareskib Limited versus Armenia, the European Court of Human Rights found that the massive opposition protests, although they posed a challenge to public order, did not threaten the life of the nation, a precondition for the state of emergency to be applied under Article 15 of the Convention. and therefore the derogation from human rights obligations under the Convention was not justified. The court further concluded that the emergency measures taken to restrict publication of the applicant's newspaper in the absence of any hate speech or incitement to violence had the effect of stifling political debate and silencing dissenting opinions in violation of Article 10 of the Convention. The court has made it clear that even if a state of emergency is proclaimed, every effort has to be taken to protect the democratic order as well as to safeguard the values of a democratic society, such as pluralism, tolerance, and broad-mindedness. There are 14 interstate cases pending before the court, of which 13 are related to ongoing conflicts. Besides, there are approximately 10,000 individual applications directly linked to these conflicts. Earlier this year, the court declared admissible interstate applications in the case of Ukraine and the Netherlands versus Russia, which, among others, contain complaints of administrative practice of targeting independent journalists and the blocking of Ukrainian broadcasters in violation of Article 10 of the Convention in the eastern Ukraine in 2014. In the same vein, in 2020, the court declared admissible the interstate complaint in another case of Ukraine versus Russia of the alleged administrative practice of suppression of non-Russian media in violation of Article 10, but declared inadmissible the complaint concerning apprehension and intimidation of the international journalists because of the insufficient proof of the existence of administrative practice in that regard. This case concerns events in the territory of Crimea between 2014 and 2015. It could be argued that both these interstate cases attest to the importance for the aggressor state exercising effective control over the territory to control also the narrative and the media. It is well established in the case law of the court that such concepts as national security and public safety, which serve as a basis for restricting freedom of expression, need to be applied with constraint and interpreted restrictively. The court, for example, has found a violation of Article 10 in numerous cases against Turkey, where individuals have been convicted for publication of statements emanating from organizations classified as terrorist under domestic law. The effect of such convictions was partial censoring of individuals and the media, although they did not advocate directly or indirectly the commission of terrorist offenses. It is when the speech exacerbates or justifies violence, hatred, or intolerance, the balance shifts in favor of restricting the speech. Moreover, the speech which is incompatible with the values underlying the Convention is not protected by Article 10 by virtue of Article 17 of the Convention, which prohibits abuse of rights. In 2020, in the case Romanov versus Ukraine, the court had to assess a situation when the applicant was convicted to 1 year imprisonment for distributing the newspapers calling for an armed civil conflict aimed at the seizure of state power by the proletariat and establishing a dominion of the working class over the others. In the court's opinion, those messages could contribute to tensions within the Ukrainian population. They constituted a threat to public order and to democracy itself, and therefore Article 17 precluded the applicant from benefiting from the protection of the Convention. Accordingly, this complaint under Article 10 was declared inadmissible. When giving a speech in the General Assembly last October, Irene Khan, the UN Special Rapporteur on Promotion and Protection of Freedom of Opinion and Expression, made the following point. What is new and deeply worrying in today's conflicts is the scale, spread, and speed of disinformation, propaganda, and hate speech, targeting civilians, particularly vulnerable and marginalized groups. It undermines human rights with audacity and impunity. Disinformation is a tool accompanying manifestly aggressive or hidden policies to reach short-term or long-term goals. The challenge at the outset is to detect various types of disinformation. In order to do so, it is important to get the picture right and to see the situation as a whole. In June this year, the court delivered a decision in a case involving the host country, Gaponenko versus Latvia. The applicant was charged with crimes directed against the independence of Latvia and incitement to ethnic hatred for a series of posts on social media where where he, among others, linked the government with the National Socialism, made calls to actively defend the spiritual values of the Russian population in Latvia, and pointed to the inevitability of an armed conflict, including a war between the West and Russia. The applicant found himself in pre-trial detention for a duration of 4 months, after which he complained to the court about the violations of the right to liberty under Article 5 and freedom of expression under Article 10 of the Convention. The court dismissed these complaints as manifestly ill-founded. In doing so, the court acknowledged that pretrial detention should only be used as an exceptional measure, since it has a range of adverse effects for the persons detained and society as a whole, and it inevitably has a chilling effect on freedom of expression. Having said so, the court distinguished this case from the Turkish cases, underlined the specific sensitive socio-political context in Latvia, and did not overlook the fact that Latvia is a neighboring country to Russia, which by the time had already invaded parts of Georgia and acquired military and political control over parts of Ukraine. Having viewed the facts of the case in their entirety, the court did not find the pretrial detention being arbitrary or manifestly unreasonable. When the convention is applied, balancing of the various interests involved ultimately depends on the particular circumstances of each case. The scale and spread of disinformation surrounding conflicts and beyond call for application of the Convention standards according to present-day needs, which includes awareness of the new threats, getting the facts right, and delving into the domestic specifics in order to see the situation in a wider context. The pluralism today demands opinions which are based on reliable, trustworthy information. It is possible to view the last year's judgment in the case NIT SRL versus Republic of Moldova, where the court did not find a violation of Article 10 when a license of a TV channel was withdrawn because it systematically had violated the obligations of neutrality and impartiality in its news bulletins, as fostering as wide range of opinions as possible, which are importantly based on accurate and balanced information. The requirements of neutrality and impartiality when reporting the news were imposed by the domestic law due to specific national context. It is tempting, though, to dream that should these principles were strictly followed everywhere, first, the quality of the public discussions would be higher, and second, there would be no war in Europe. Thank you.
Thank you. And so essentially what we're really trying to tease out then is the moments in which it's acceptable to limit freedom of expression and media freedom, and how much more complicated that becomes in a time of conflict and war. It's complicated enough at the best of times around hate speech, incitement to violence, but all the more complicated in a febrile situation like a conflict. So I want to begin by asking Yulia Derkachenko, who is the representative of the Ukrainian Parliament Commissioner for Human Rights, about this. Obviously, Ukraine is one of the areas where we're thinking about this the most. And in the context of limiting media freedom in times of war, what are the main problems that you see for journalism in Ukraine today?
Thank you for your questions. First of all, I would like to thank the representatives of the Latvian side and the Council of Europe for the invitation of the opportunity to participate in the conference. In the year and 7 months since the start of full-scale invasion, Russia has committed 566 crimes against journalists and the media in Ukraine. Namely, 66 journalists were killed, 10 of them during their professional journalistic activities. The Russians killed 6 foreign and 60 Ukrainian journalists. Media workers were captured or kidnapped 22 times. In particular, Union News Agency journalists from the temporarily occupied Melitopol are currently being held captive by the occupiers. 24 journalists were injured as a result of Russian shelling. These are the data of the monitoring of Russian crimes against journalists and the media, carried out by the Institute of Mass Information. Hundreds of media closed forever. Thousands of journalists left the country. Some joined the ranks of the armed forces or became internally displaced persons. The financial crisis, a lack of electricity in winter, the narrowing of the content to military themes, the personnel crisis, a huge increase in the workload, and in parallel with this, everyday shelling, stress, security challenges. In all this, the Ukrainian media managed to strategize, produce a quality product, and even compete. Because the safety and the life of people and their events depend on the quality work and responsibility of journalists. Having suffered losses, human, materials, psychological, Ukrainian journalism nevertheless becomes a full-fledged social barometer and has yet to become a watchdog of Ukrainian democracy. The high-quality work of journalists allows us to convey to Ukrainians and foreigners the true picture of the war in Ukraine and to ensure the support of many countries around the world. At the same time, preserving freedom of speech during such a bloody war is an extremely difficult task. Thank you.
Thank you. We've tried to condense some of the remarks, and I'm grateful to the speakers this morning so that we can have quite a lively conversation, because I think this is a challenging topic. I want to turn to you, Kristina Pakakli. You're the legal advisor of the Ombudsman of the Republic of Latvia. And I want to talk to you about how this issue impacts Latvia in particular. There's been obviously the controversy around the cancelling of TV Rain's license. EBU this week warned that the plan to end funding for public media in the Russian language may be a violation of human rights. I want you to talk about how the issue of setting freedom of expression and freedom of media against national security issues plays out in Latvia, and how you see this. Is it an issue of humanitarian law, human rights law, both, neither? That's a lot of questions.
Yeah, thank you very much, and thank you. I would like to thank also the organizers for inviting me to this panel. Yes, indeed, Latvia is Russia's neighboring country, and last year the war in Ukraine shocked us, but the second thing was that there was an information war in propaganda media that were available in Latvia for many years. And actually, they were available really for many years, and they were restricted only on exceptional occasions. Yeah. But last year, as I mentioned, this was exception, because media, these propaganda media, were full of distorted facts, manipulation of history, manipulation about the war in Ukraine. Yeah. Saying at the beginning, this is a special military operation. This was like a reflection of the narratives from Kremlin. This was really a reflection of these narratives. And the logical step was taken by our regulator, by National Electronic Mass Media Council, that they actually, during the course of the year, they restricted all Russian propaganda media channels and a lot of web pages as well. Yeah, but of course this was done due to on several legal grounds, due to violations of Latvian electronic mass media law, which prohibits also the incitement to violence, incitement to war, incitement to ethnic hatred, yeah. Then as well due to violations of Audiovisual Media Services Directive, and due to violations of sanctions imposed by EU. And if you look at the reasoning behind, yeah, then the Council, the regulator, also used this criteria set out in the case law by Strasbourg Court, analyzing the legitimate aim, of course, and proportionality. And it must be said also that all of these decisions are administrative acts, then they could be appealed. Some of them also were appealed, and they are temporarily. If we look, let's say, once more at these decisions and the analysis of several broadcasts, then the broadcasts were, just to take one example, that in program Russia RTR, it was one episode, among other things, the position is expressed that the Baltic countries is the territory of Russia, They are, of course, manipulating of facts and denigrating Western states and its policy in NATO. This is the narratives that we all know, And I quote, the West and NATO have already come to Ukraine. They are already in the Baltics. But this is a territory of our country. This is a narrative taken from this one broadcast. Of course, as also the distinguished judge has pointed out, that freedom of expression is extremely important right in the democratic society, and as all human rights lawyers know, that it also refers to expressions that shock and disturb certain part of the society. It really shocked, but I would say in a very negative sense. It shocked in a very negative sense. And what also European Court of Human Rights says, that the freedom of expression doesn't refer also to information that incites to hatred and to violence. And these were really the cases. And it was also stated in several EU documents, like, for example, European Council document from last year, 1st of March, a regulation that Russia has engaged in a systematic media and media manipulation and distortion of facts in order to divide the civil societies in neighboring countries and in order to undermine also democratic institutions. But since this was really a shock, and the massive closures of these, I would say, media channels, propaganda media channels, the Ombudsman met with management of regulator. We discussed these issues, let's say, to see really this reasoning behind, and also to discuss the prospects in the future, how to, let's say, to provide pluralistic media scene, including also in Russian language.
Thank you. And I want to come back maybe to the panel in a little while about how we define and think about propaganda. CPJ raised its concerns at the time around the cancellation of TV Rain's license, and I think that's something I'd like to tease out in the panel. While we're on the subject of regulation, I'd like to turn to you. Carlos Aguilar Paredes is the Vice President of the ERGA, a board member of the National Authority for Competition and Markets. And I just want to talk to you about what is the European Regulators Group for Audiovisual Media Services? What do you do? And more importantly, what are the legal tools that are available to regulators to enable them to deal with these kinds of issues?
Okay, thank you. First of all, I want to thank the Latvian Presidency for having us and just to invite the European regulators to include in this discussion. And the launch of the IRGA was established in 2014 by the European Commission, as it consists of the national independent regulatory bodies in the field of the audiovisual services in the European Union, and has three main tasks. The first one is advise and assist the Commission to ensure the consistent implementation of the Audiovisual Media Service Directive. and advise them in other matters related with the social media services. The second one is to facilitate the cooperation between the regulatory bodies. And the third one is allow to the change of best practices among the members of these authorities. We have, in these 9 years, we established a year program just to follow all the issues and the topics related to the media services, the new legislation, and to follow topics as media literacy, disinformation in this work, in this continuous work. No, you can find all of it. And finally, in our advisory task, we have provided views in the last European legislative initiatives that have impacted media, as the revision of the Audiovisual Media Services Directive or the Digital Service Act. And now, as many of you, we are been working intensively in promote some amendments in the future European Media Freedom Act. No? So, okay. Sorry. And related to the second question, I will try to go shortly to the point because it's very difficult after the intervention of the keynotes of the judge and the previous to add very few things. But it's absolutely clear that freedom of expression is one of the pillars of the democracy. But at the same time, we cannot forget that the democracy is also based on the respect of the broad of fundamental values. And unfortunately, in the current audiovisual environment, these different fundamental pillars often come into conflict. And this is especially the case where someone claims to the freedom of expression for deliberate use it to undermine some of these fundamental rights. And that happens especially in times of crisis. When the right of speech is perverted to deliberately and systematically violate the right of the citizens to receive the truth information, or to incentive to hatred or violence, or to attack systematically groups, it could be journalists or another one, that highlights the needs for mechanisms to limit the scope of these deliberate actions. Although these mechanisms can be considered in the same way a restriction of freedom of expression, the action of regulator when applying these different pieces of law cannot be measures ever against the freedom of information or against the possibility of journalists to carry out their work freely. On the contrary, it should be served to highlight those best practices in front of the harmful content to allow the citizens to receive the necessary information from all possible perspectives to allow them to take informed decisions. The Audiovisual Media Service Directive clearly indicates that the application of the rule relating to the restriction and the supervision of the freedom of expression has an exclusive national scope. So allow me to focus on those elements that are common and will involve different countries that can contain some restriction of this freedom of expression in the Audiovisual Media Services and in the Digital Service Act. Under the Audiovisual Media Service Directive, a member state may provisionally restrict the retransmission on its territory of an audiovisual media service provided by under the jurisdiction of another member state. And that is in a very, very few occasions. One is a serious and grave risk or prejudice the public security, including the safeguard of national security and defense. And in this decision involves the intervention of ERGA as an advisory body and of the Commission as guarantor of the measures taken by the member state that are compatible with the union law. And this very exceptional procedure includes several guarantees. I will not come in. But I would like to remark two reflections about this forecast. The first one is that the narrative that establish the crisis situation are not abruptly. Then, as supervisors, we need to make constant supervision and take decisions if it's needed in order to sanction a broadcast system or any other media, and in order to be strained decisions that not only apply on crisis situation, even in the day. And the second is related on the limited capacity of this provision, just to to accomplish the goal that is pursued. Because in the actual digital space, there are different channels where the informers arrive to the people. And that gives me to the Digital Service Act and the future ENFA. And just to summarize, the Digital Service Act has, in summarized, two provisions. The one is that the very large online platform must implement measures to identify and mitigate systematic risk. And on the other side, when there is a crisis situation, the Commission, acting upon the recommendation of the European body or digital services, can adopt a decision requiring one or more providers of very large online platforms or a very large online search engines to take some actions. And in terms of the basic elements that come in conflict or can come in conflict with the freedom of expression, these procedures might involve the moderation of contents or the modification of the algorithmic systems. And to finalize this first intervention, in this case, we have, with all the necessary precautions and respect to the rights freedom included in both laws, it's true that they have provided regulation and mechanisms that limit the free circulation of content. That is a reality. And as regulator, we have a special responsibility on their application.
Thank you. It strikes me that national security does a lot of heavy lifting and a lot of this regulation and legislation, and something that perhaps we can come back to in discussions. I want to turn now to Tuija Saresma, professor at the University of Jyväskylä in Finland. I want to move away a little bit from the legal framework, the regulatory framework, and to step back a little and wonder if you can talk to us about stochastic violence. In other words, the relationship between cause and effect in the context of hate speech, and what specific issues that gives rise to in a situation of conflict and war.
Thank you. So already on, right. Good morning. It's great to be here, even the topic is quite not so nice. But I'm enjoying the conversation already. So I would first like to emphasize that hate speech is a societal problem as well as a legal one. So yes, I hope we can come back to that maybe later. So hate speech is harmful because this has been agreed generally, that it threatens equality, personal dignity and security. So it threatens security as well. It endangers the rights of various minorities to non-discrimination. And most importantly for today, it endangers freedom of speech, democracy and the rule of law. So it has negative consequences for both individuals and the whole society. It affects communication and information, politics, the work of professionals, and freedom of speech, which is, of course, a pillar of democratic society. And in our research, we have focused on the hate speech that politicians get, that they are the targets of, but also politicians use hate speech. And as we heard yesterday, there are actually open attacks against journalists, for example, from a very high political level. That was in Latvia, I think, but that happens in Finland as well, and Finland is where I come from. Also a member state, a neighbor of Russia, but in a quite different situation than well, obviously Ukraine and also Latvia. But when politicians use hate speech, it becomes especially harmful because politicians, of course, occupy an influential position and status. They have wide distribution networks, and their persona gives credibility to their message. And here is when I come to stochastic violence. In our research, we suggest that social media texts that are interpreted as hate speech should perhaps be analyzed as a form of stochastic violence. And stochastic violence is something that positions the creators of hate speech actually as innocent and in that way restrain any criticism towards the hate speech producers while intentionally violating their targets. And in our case, we studied the media texts, the tweets and blog texts by the former President Donald Trump and the former chair of the Finns party, Jussi Halla-aho, who is now the Speaker of Finnish Parliament and running for presidency in next year elections. So hate speech can get people very high in political hierarchy, and that is what has been happening in Finland, for example. So what is actually stochastic violence? It refers to the simultaneously predictable and unpredictable nature of violent speech and its consequences. And so there is a sort of conscious employment of stochastic violence that may or may not inspire small cells, for example, to terrorist actions, these so-called lone wolves, but we don't know when and where, so it's really unpredictable. So we are not arguing that there is a direct link between racist ideas, right-wing parties in parliament, and acts of terrorism, but we say that the normalization of racist discourse, for example, or othering discourse when people are creating enemies, it will open the door and it will legitimize the ideas behind acts of violence. So it's not just words, but words can incite to violence.
And in other words, it doesn't necessarily matter whether the speaker intended to incite violence. That may happen anyway as a result of certain kinds of language and words, and therefore understanding what those words are in what context may create the conditions for being able to limit that language. Is that right?
Exactly, yes. We don't know what will happen, but we know that something will happen when we use violent language and when we incite people to.
Because obviously a lot of the current legislation in many countries relates to people's intention, but this would be something different, which may come back to the question of what constitutes propaganda and where you might limit certain kinds of organizations. We'll come back to that, I think. I want to come to platforms, which have had quite an easy ride the last 2 days, which is unusual. Let's change that, Aliska. Aliska Perkova is the European Senior Policy Analyst and Global Freedom of Expression Lead at CPJ Friends Access Now. I want to ask you about internet content governance in 4 minutes. What does that look like in times of crisis or war now, and how do you get towards a principled approach to content governance that kind of marries these questions that we've been talking about?
Thank you for a great question. Good morning, everyone. So Access Now is a global human rights organization that defends human rights on internet, which gives us extraordinary position to be able to monitor several world regions and compare the situation and finding common patterns among the countries. And when we speak about freedom of expression or more general international human rights law in times of war, I want to ensure everyone, and this is obvious to everyone, that the law still applies. And even though freedom of expression is not absolute right, international human rights law, as well as international humanitarian law that kicks in such situations, have quite strict rules in place how to actually regulate free speech, either online or offline. What we see and witness in the field, either from the private actors, but equally from states, is how the terms such as disinformation, propaganda of war, incitement to violence being often blurred and mixed up, and different legislative or even platform-level responses then being applicable in a disproportionate manner. Of course, disinformation is not the same type of the content as propaganda of war, which is actually the part of Article 20 in the ICCPR, so the type of content or type of speech act where the last resort measures are applicable similarly as incitement to violence, hostility, or discrimination. But during my first intervention, I would like to quickly elaborate on a few cases that we see when it comes to time of war and how online platforms are being used or misused by actors in these conflicts. And maybe in my second intervention, we can look at the response of platforms and where we see the gaps and often ongoing negligence in different situations of crisis around the world. So first and foremost, we often see how different military operations try to use platforms to advance their military objectives through the spread of different false information, which to some extent under international humanitarian law can be understandable, but not under circumstances if such information could impose incidental harm to civilians. And I can give you a concrete example. In 2021, the Israeli military forces successfully misinformed also journalists and known famous journalist platforms such as New York Times about their intended invasion of Gaza, and started contacting journalists saying we will have to warn civilian population. In reality, this invasion never happened. It was just one way how to actually achieve military objective against the adversary, which can have catastrophic consequences for the civilians living in that area. Another example could be the spread of information with the intent to terrorize civilians on the ground. And we see that all over again happening, even though some of those cases are rather blurry. One example could be, for instance, to some extent at least, the threats of the Russian invaders in Ukraine to, in one way or another, endanger the security and the stability of nuclear power plants on the Ukrainian territory. Another example could be to disclosing the information about the civilian houses in the occupied territories by Israeli military forces on Facebook that we also monitored, and this is something that does happen on a relatively regularly basis. Now, another example could be also the publishing information about the forced displacement of civilians. A number of different parties to military conflicts around the world often do that, even though under the rules regulating non-international armed conflicts within the international humanitarian law, this is actually not allowed. This is done with the intention to actually move whole entire parts of population and create that threat of danger in order to, again, advance military goals. One of things that became much more visible during the illegal invasion of Ukraine was, for instance, the content depicting the prisoners of war that we saw gradually spreading on platforms such as Meta, but also other social media platforms. We also saw platforms rushing into changing their content moderation policies in order to capture this type of content and starting interpreting the very complex rules of international humanitarian law themselves. And we're always very cautious when we see private actors doing that with not sufficient public scrutiny and understanding how these terms and conditions are actually being adapted. And also a number of other examples that directly can actually put people in danger, and one very obvious, of course, incitement to genocide, which is prohibited under international public law. Myanmar is a very typical example, but we see similar developments in other parts of the world too, including, for instance, Ethiopia, and also incitement to violence, hostility, and other clearly illegal type of online content or speech acts in general, where international human rights law offer sufficient guidance how to proceed. These are just a couple of examples to see how complex this situation can be and how many different legal fields we have interacting in this area, and where platforms often have to navigate, but also where platforms are, in most of the cases, last resort and access to adequate information for civilians and often to journalists as well.
That's really helpful. And I think one of the challenges clearly is, even if you could identify, say, the governments as engaging in this, by the time it's being dispersed on platforms, there's all sorts of other players disseminating that information, from individuals to broadcasters, to freelance journalists and others, and the challenge of identifying who is doing the dissemination and how to tackle them, which is clearly why often states resort to just simply pulling the plug on the internet altogether. I'm going to encourage the audience to start thinking about questions. I'm presuming we have a microphone somewhere, because I do want to ensure that you have a chance to ask your questions. I'm going to come back to you, Julia, to talk about what role the Secretariat of the Ukrainian Parliamentary Commissioner for Human Rights can play in protecting media freedoms, particularly at this moment. We heard yesterday from Olga about the challenges that she faced in having not only to deal with kind of what's happening just to cover war in your country, but also to make sure that she can continue to report freely. What role does the Human Rights Commissioner play in managing all of that?
Thank you for your questions. The Office of the Ombudsman did not stop its work for a single day during the full-scale invasion. In the prism of journalist activities, the Ombudsman of Ukraine receives a significant number of appeals from journalists concerning rights violation. During this period of the war, 481 appeals were received from journalists and media workers, 4 of which were about violation of the rights to freedom of thought and speech. According to appeals of this category, 2 criminal proceedings were initiated in response. All others relate to the protection of personal data of citizens, the exercise of the right to appeal on the timely receipt of public and social important information in wartime conditions. Among the successful cases, we can mention the case when we renewed the rights of a news agency journalist to receive public information about the salaries of the ministry's management staff. With our assistance, the ministry re-examined 30 requests of the journalist and provided information in full. We can also tell about the case when, with the assistance of the Commissioner's Secretariat, the right of access to public information was restored to the journalist regarding the depersonalized list of vehicles imported and registered in Ukraine through customs points during the war. The institution of the Ombudsman should not be a bureaucratic institution, but a place where journalists feel respected and protected, where they are heard and helped in solving their problems. Often the Ombudsman is the last hope for help, and we have no right to waste this hope. Thank you.
Thank you. I like to hear the words respected and protected. I have a number of questions for the rest of the panel, but I don't know if anyone in the audience has a particular question. Right at the back, there's 2 questions there. Let's take these 2 at the back together.
Which one? Yes. My name is Peter Norlander. I currently run Reporter Shield, if anybody has questions about that. My question is about the rule of law in all of this, and it's directed at Judge Mitz, I think, who mentioned the case of Gapanenko versus Latvia. Now, what happened in that case was Mr. Gapanenko, who is a pro-Kremlin, very unpleasant, thoroughly nasty piece of work, I'm sure, posted on Facebook a series of posts which were, pro-Russian and inflammatory, although they were not inflammatory to the point of being hate speech, as the court itself points out in its decision. What happened, though, is after he posted these posts on Facebook, he was put in pre-trial detention. He wasn't convicted of anything, but he was put in prison for 4 months on the basis that he might have committed a criminal offense. That was in 2018. He spent 4 months in prison on the basis that he should be prevented from accessing Facebook and posting further messages. So it was basically he was put there preventatively to make sure that he wasn't going to be able to access the internet again, because whilst in prison, he didn't have access to the internet. In August, 4 months after he'd been put in prison, a judge ruled that, yeah, there was no longer a risk of him posting further messages on Facebook, and so he was released. So he'd spent 4 months in prison on the basis that he might have committed a criminal offense. He was never actually convicted of committing a criminal offense.
You need to ask a question.
Yeah. My question is, how is that compatible with the rule of law? Because he wasn't convicted of a criminal offense. He was just put in prison on the basis that he might have committed a criminal offense. Is that where we draw the line in these situations?
Thank you. And there's a question in front of you. We'll take that one too.
Thank you. I will be really short. So, we know that when revealing state-sponsored violence or state crimes, the line between being seen as a hero or being seen as a streeter is really thin. And I was wondering what was your opinion on the extradition of journalists or other media actors from Europe to other countries where they could face political prosecution, arbitrary detention, torture, etc. As this can have an important chilling effect on those who want to reveal states' criminality worldwide. Do you think the member states of the Council of Europe has responsibility in the legal protection of journalists worldwide, with who they have a jurisdiction link, especially for non-national that publish informations from the European territory? Thank you.
Thank you. Okay, so Judge Mitz, can you take the rule of law question, and then perhaps we can also bring in some of the other panelists on the other questions.
Is it on? Yeah. So I think you already started answering yourself the question. We simply have to give more and more details of the case. And basically all of them are in the decision. But European Court of Human Rights does not act as a fourth instance. You know, it doesn't say what was right, what was wrong. It works on the basis of reasons of a decisions of the domestic authorities. That's what we scrutinize in that case. And just one more nuance about this particular case to say, and without going into more detail, is that there was another charge brought against the applicant concerning conspiracy against the independence of Latvia by cooperating with foreign services of another country, which in that case was Russia. But of course, you are right pointing out that if the consequences of what the person writes is putting in pretrial detention, sort of a preventive, that per se is a problem. But in this specific case, actually the domestic authorities were also arguing that the less severe measure would not be appropriate, because this is through this way how the crimes, which apparently are very serious, are being committed, and that was the way how to also stop them. And for the court, in the very specific circumstances, in view of the background and in view what the person was writing and what was how sensitive the situation was in Latvia, that was acceptable. But this is a very very fine balance that has to be made. And besides, there's another application concerning, by the same applicant, concerning the conviction. Yeah, so this case dealt only with pretrial detention of the person.
But in this case, right, when we're talking about restricting media, cancelling someone's license, putting them in detention, I think where we're getting to is necessarily that needs to have the highest levels of, you need to be able to prove the highest levels of threat for that to be acceptable, right? You can't just sort of allege that there might potentially, possibly, in some future instance that you can't, I think part of what we're getting to here is that a lot of governments use quite vague, quite broad national security laws to restrict people's rights in these instances?
You're absolutely right. The whole point is that I was also trying to convey is that we don't need to invent new principles. We have to work on the basis of the principles, but we have to be aware of the situation, put them into the context of the particular context. And of course, we have huge case law in the European Court of Human Rights where, exactly as you say, the concepts of state security, public order are used somewhat indiscriminately in a very easy way with the consequences which are very far-reaching for the freedom of expression. Therefore, this is really, we have to be aware how serious indeed is the threat to public security.
And I just want to build on that and bring Christina in from the Ombudsman's perspective, and we'll come back to the extradition question in a second, is how then from the Ombudsman's perspective are you balancing those considerations around the need for very specific, clear guidance on what constitutes a threat to national security and so on, with an ability to report freely?
Yeah, as it was already mentioned, the context is extremely important. Of course, also in times of war, in times of conflict, the rule of law and the rule of law applies as well, of course, yeah. And there is several sections in Latvian criminal law regarding the incitement to ethnic hatred and justifying and glorifying of war crimes. This I would just in some sentences elaborate that somehow there is a link between what I'm saying now and between and my previous intervention. Because there is, and it comes from several studies, really from many studies, that there is about situation in Latvia, that there is a clear link between this consumption of propaganda media for many years and support of Russian invasion in Ukraine, clear support. From some individuals and also afterwards justifying of war crimes. This is something terrifying, yeah? And let's say to punish these expressions that are not within the limits of freedom of expression, that justify, glorify, deny the war crimes. This is not only in Latvian criminal law, this is of course according to EU framework decision from 2008, that all states should punish such expressions. And actually, during the course of war, we experience that there are many expressions, justifying war crimes in this is mainly in social networks, in Facebook or Meta and TikTok and YouTube, and we were asked, several criminal investigations have been started regarding these issues, and since this freedom of expression is a very important right, we were also in several cases asked from law enforcement authorities to give our conclusion, let's say, regarding these cases. And what we used analyzing these expressions, we used also the well-established criteria in European Court of Human Rights case law and Rabat criteria and ECRI criteria, which are quite similar. And of course, this content is extremely important, and also the persons who express the particular comments, personality, and we saw, let's say, expressions from ordinary people, so if I may say so, that are regarding Ukrainians, regarding also Latvians, that they need the same, let's say, destiny as Ukrainians, and also expressions coming from community leaders, so to say, which are very, very powerful because they influence the audience, yeah. And in several cases, we saw also that the audience is many thousands, and they involve in this discussion. They also comment, yeah, okay, let's invade, and so, and let's eliminate
which
all
was Tuya's point about the power of an individual,
yeah,
and the position that they have. And I know, of course, that you mentioned glorification, and I know that while there is law concerning glorification or outlawing glorification of war or terrorism in much of Europe, that there is some international concern about that as to whether that should be something that we outlaw. I want to ask, I don't know whether Tuya or Aliska, you want to talk about this extradition question. It's slightly separate. Or we can come back to that. I mean, it's clearly an issue for, I think, the Council of Europe states that not to be seen to be enabling suppressors outside of the Council of Europe. But maybe we can come back to that in a second. There's a question at the back on my left, up here. And then we'll come down here.
Thank you. David Blencathra, United Kingdom. We are sitting here in these comfortable surroundings as lawyers, journalists, politicians, and we're not under any threat. But Ukraine is. Ukraine is fighting for its very existence. And if it loses the war, there will be genocide, and hundreds of thousands will be killed. So could I get the panel back onto what is supposed to be the subject of this discussion, media freedom in times of war? And with respect, it's not about hate speech in Finland or individuals in Latvia being arrested, but it's about the role of the media in, for example, Ukraine, in telling the truth or aiding the military power to help win the war. To give an example, the independent BBC during the Second World War worked hand in glove with the government to make sure that the truth was told, but not necessarily in real time, some days later. We would never have liberated Europe in 1945 if the media revealed the date and time and place of the Normandy landings. So would the panel therefore agree that in the situation in Ukraine, the media must control their demand for complete freedom of truth immediately and cooperate with the government to make sure that at the current moment that genocide does not take place and they actually are successful, and then the details can come out later about the military operations?
Thank you, David, for your question. Actually, the title of this session is Legal Limitations on Freedom of Expression in Times of Conflict and War. Yesterday's panel was more focused on the role of the media in times of war. We're looking specifically around what international law and national law can and should do around the role of the media. And I'm sure Julia may talk a little more about the ability of the government, or whether or not the government should require the media to do anything in terms of coverage, and we'll come to that after a question here.
Thank you very much, Jody. William Horsley again. I'd like the panel of Judge Mitz and perhaps Professor Smith to give us clarity on the action of the European Union very quickly after the invasion to do a blanket ban on Russian, those Sputnik and RT in particular. I think people are still confused. There's two issues. There's the one of principle, was it the right decision, was it justified, but also that of process, because it was in effect an executive decision. Due process, one could say, was not followed, and indeed some member states were obliged to remove that option to their listeners simply because of executive decisions in Brussels. Thank you.
Thank you, William. Thank you for raising that. I know it came up in yesterday's panel briefly as well. Judge Mitch, do you want to take the first question? Maybe Carlos as well. We can bring you in on the question of blanket bans on certain media, and Aliska too. You start, yeah.
Just on the last question, all I can say is that indeed the European Union imposed sanctions against 2 TV channels, and then a number of EU member states, as well as non-EU member states, have taken more steps with respect to more Russian TV channels. The European Court of Human Rights, which is not EU court, but Council of Europe institution dealing with 46 member states, have not dealt with such a case, but potentially, probably it might come up before the court, so I can say no more about this.
Carlos, do you want to talk a little bit about that from a regulatory perspective and the role of regulators in whether or not they should and could introduce blanket bans on certain kinds of media outlets, and then we'll come to Aliska.
Yeah, thank you. But I will, to be short, I will focus on 3 points. There is, as we're talking, a balance, especially in crisis time, where need to be in one side the freedom and another side the respect of the other values. And as regulator, we throw that the coming emphasis is a piece that is going to help in 2 ways. The first one is to strengthen the capacity of the freedom of the journalists in terms of editorial capacity. And the second one is related to the provisions of the directive, just to address it to the capacity of platforms to ban contents. And it's around the proposal of the Article 17 in the European Media Freedom Act. And we, as FERGA, has made several amendments of this provision, trying to improve that, because we really believe that it's very important that exists this media exception, but we need to be sure that these ones that are selected as media with consistent editorial standards are well defined, that are well selected. And on the other hand, we need to be sure that the platforms cannot decide to restrict this application of TV and this kind of media. And we are proposing the intervention in some way of authorities, regulatory authorities, to support that. This is one of that. The other one is related at several things that have been said, that the ERGA has been working hard in definition of what is the disinformation since 2018. And in several cases, we have worked, we have been claimed by the European Commission and other, for instance, in time on COVID. And of course, after the aggression and invasion of Russia to Ukraine, just in order to establish and to understand how work these narratives of misinformation and how these ones are disseminated. And because this is the base, and a common understanding on that is a base in the Union for that all the regulators can apply that any sanctions that can be imagined or that can contain the law, but in a consistent way. And we have made several reports about things that look like easy, but it's not so, as the definition of what is misinformation or what is not. And yes, relating to one of the questions that have been made, the Audiovisual Media Directive and the Digital Service Act give a very important role to auto-anchor regulatory.
Sorry,
so auto-anchor regulation, and it's in these points where the media and platform have to take these provisions and what will they do in different situations. And then I mean that it can or has to include crisis situation and war situation. And this is a decision that has been taken by the own media, we cannot be imposed. But it's a different way. And as a regulators, and we have the capacity to impulse or in some way supervise these codes, and then I think that we can help. We cannot do it, but we can help to address in the correct direction. And I want to make a last remark about the paper of the regulator, as we have several of us have the capacity to impulse the media literacy around the countries. And I mean it's not directly related right now, But in this context where the true information and the disinformation is fighting, especially when there is no time because a crisis time, is very, very, very important that we can establish a mechanism for good media literacy in our society, especially in the young.
Yeah, and I know that a couple of people have mentioned in various panels this question of media literacy, and I think it will be interesting to see how, in the context of safety of journalists, the Council of Europe and others take that forward. Aliska, you want to come in?
I also would like to say a few points on the ban regarding RT and Sputnik in the EU. The ban does not concern only the traditional media, but also online space, because it concerns broadcasting, for instance, audiovisual content. And we actually took quite some stand on this ban, and in principle, again, given if this ban concerns only the propaganda of war, we understood the European legislators why they actually arrived to that decision, but we would like to see more public scrutiny in the decision-making process. For instance, allowing European Parliament to also has its say on whether such a ban should be applicable. What remains, however, unclear is the enforcement and implementation of the ban, because in theory, the way how it's being enforced, it ultimately will lead probably to general monitoring, which means all the content being posted on the platform is being scanned by automated technology in order to detect what content can potentially fulfill that criteria within the ban, and that is prohibited. That is prohibited within the Digital Services Act and previously through the e-commerce directive. What is more worrisome is that to this date we were not able to obtain any solid data about the enforcement of the ban, and CPJ led excellent freedom of information requests that we chipped in, and we did not get sufficient information. We think that this information probably lie mainly with the national regulators, who are much better equipped to actually enforce such ban, which would be, of course, a very burdensome activity now to go through each member state and try to figure out how it's being enforced. So principally, yes, its enforcement is highly problematic from the international human rights law viewpoint. And one more thing that I'll quickly add, yes, framework decision does serve as a legal basis for many legislative acts or co-regulatory acts in the EU, especially those that combat illegal forms of hate speech. I would have a question whether that framework decision would meet the threshold of rapid plan of action nowadays, or also the test of international human rights law. And there is a lot of critique also around the terms such as glorification of terrorism, that due to its vagueness, it can actually lead to disproportionate impact and does not meet the criteria of proportionality and necessity. Thank you.
Thank you. And I know Tuija has some thoughts about how we can kind of have a more nuanced approach to hate speech, which I'm going to ask you about in 1 second, but I want to make sure that we address this question of the relationship and the role of the media in supporting national government in times of crisis. And maybe, Yulia, you could help us think through how the Commissioner helps to balance those things effectively. And I know perhaps you might want a translation.
Thank you for your questions. Офіс уповноваженого підтримує діяльність, звичайно, і здійснює парламентський контроль за органами державної влади місцевого самоврядування. Що не так? І в цьому випадку дійсно роль медіа дуже висока, і ми цінуємо саме уповноважений, велику роль приділяє саме і звертає увагу на діяльність медіа в Україні.
I'm going to let you pause there for your translator.
So the Commissioner plays an important role in monitoring the observance of the rights of media and journalists in Ukraine, and he also supports very much the role and the work of media during these hard times of war in Ukraine. And he also makes everything possible, so the commissioner itself as the office makes everything possible to maintain the work of journalists and to highlight what are the problems and how to cope with this, with all these problems, and trying to initiate different work to ensure their safeness regarding these difficult times. Thank you.
And just to add to that, does that mean that the Ombudsman can limit any government overreach? So you mentioned, for example, that you were able to persuade the ministry to release salaries, for example. Does the Ombudsman have power to push back against the government if they try and limit what the Ukrainian media can do?
Я відповім українською, пані Мар'яна перекладе. Уповноважений захищає права журналістів і ні в якому випадку він не обмежує діяльність журналістську. Ми захищаємо права всіх громадян України і журналістів відповідно. І в цьому випадку уповноважений не ставить певні умови. Уповноважений здійснює парламентський контроль за органами державної влади, місцевого самоврядування і захищає права громадян.
So basically, the commissioner does the parliamentary control over the observance of the rights of human rights, basically, and also as the rights of the journalists. So he does not limit probably the government's. Not the government, but whenever. So basically, the commissioner protects the rights. So whenever there is a violation, regardless of any governmental institution or a non-governmental institution, the commissioner, his main role as an institution to protect the rights of anyone. So it doesn't mean. So whenever there is government but violates the rights of journalists, he will protect.
Okay, thank you very much. So there's two big questions that I want to ask before we wrap up. The first two relates to this question of how to address hate speech. We've already talked about various different kinds, including all the way up to glorification of terrorism, incitement, so on. You, I think, advocate a more nuanced approach to how we think about addressing it. Can you talk us through a little bit what that looks like?
I'd be happy to. So yes, I do emphasize that it is not actually only the illegal or like criminal hate speech that is dangerous, but I mean all kinds of hate speech actually, and the concept of hate speech is a difficult one. As we know, how to define it in the law and how to define it in general language, and we have thought that maybe it should be like we should not always talk about hate speech because it's not always hatred that is behind that, or it's not always like angry speech. It can be very rational. The tone of it can be something else than hatred, but it can still be really harmful and it can really incite people to violent action. So it could be talked as dangerous speech or extreme speech, but it's not always extreme either. Harmful speech, yes, it is harmful that we know. I have lately come to think of the concept of toxic speech as a good one because it kind of describes how the speech that would not perhaps be violent in small doses will eventually, when you're exposed to it, like year after month, year after year, like many journalists, for example, do, especially women journalists that get a lot of hate speech or toxic speech online, for example, it really accumulates. And then it can be like really, it can have really bad consequences for people. So yes, I think, and when it comes to war and what we should be talking about in this panel, I think that yes, it's really important to talk about the situation in Ukraine, but we also have to acknowledge that there is usually hate speech that precedes war. There is this black painting of the sort of enemy, that the ones that are constructed as enemy, and we construct this enemy who must be destroyed, or they will destroy us. So propaganda always precedes war, and hate speech always precedes war. So I think that we should be really careful about what's happening at the moment. Like say in Finland, that is a strong democracy. We need to keep that going. We need to nourish the sort of environment that allows for multiplicity of voices and opinions, and free speech and freedom of expression, because as we are now hearing the voices that try to keep, for example, researchers and journalists silent about certain topics, and we are there already heading towards something really bad. So I think that it's not just the illegal speech that should be, that we should be afraid of, but all kinds of speech that is aimed at harming at certain, for example, minorities. We need to be really careful.
But would you be advocating then to make that currently illegal, harmful speech illegal, or addressing it in a different way?
There must be many ways to tackle this. I mean, law is one of the things, but also we need, as we have been talking about media education, and yesterday I was discussing actually with with someone from the Finnish embassy, that it's not just media education as such, but we need social media education. So we haven't had that much, and that is because it is the social media environment that is really circulating most of hate speech, and TikTok was mentioned, Instagram, even Telegram, Twitter. So we need to educate people to discuss there, and we need to have more research. Obviously, I would say that because I'm a researcher, but we need to have measures have to be taken in local and national and European level. So. But it's really hard to say what to do, actually.
But the social media point brings us nicely to Aliska. I think one of the challenges that we've seen in recent years is that when we've come to the limits of legislation, often legislators and regulators turn to social media companies to sort of magically fix a societal problem. Can you talk to us about some of the ways in which you think, from Access Now's position, we ought to be thinking about the role of platforms and perhaps the role of community content moderation as a potential solution?
Absolutely. So I'm going to use the word which I think will be understandable, but I will explain in a minute what I mean. And there is an interesting shift also in the response of platforms, which is motivated pretty much by the shift within the way how lawmakers are responding to these different societal phenomena, such as hate speech. And I'm very happy that you mentioned the silencing impact on marginalized groups, because that's a major issue that prevents them from participating in public discourse. So we now have the modern legislation in the EU that actually directly poses obligations on platforms. We call them due diligence obligations, and they've been around for the longest time. And these obligations are actually regulating platform systems and processes processes how they respond to online hate speech or other categories of illegal content, but also the content that is still legal but potentially harmful, such as disinformation. And these due diligence obligations focus on forcing platforms to assess the risks that stems from their systems and processes, which is, by the way, incredibly essential also in times of crisis, and we constantly demand heightened due diligence from platforms even before the conflict happens. Because platforms operate in the market for a while, they usually see the first sign of escalation of crisis, and still they are very negligent and seem to be very surprised when the crisis or the war reaches its peak and acts when it's often too late. These risk assessment measures are now mandatory for very large online platforms, for big tech companies, and they capture the risks to fundamental rights, freedom of expressions, but not only, also discrimination and other societal risks. Then there is an importance of independent stakeholder engagement. So platforms need to speak to those who know the field, who represent marginalized groups that are often target of hate speech or propaganda or war or historically oppressed groups, but also those, for instance, who do know who are independent media, who are reliable sources in the country, who they need to work with. And these systems have to be formalized and they have to exist, again, a long time in advance before the crisis escalates. So rather than going after concrete categories of content and forcing platforms to filter and use more automated decision-making processes that will always do mistakes and have negative impact on fundamental rights, we need to actually find an evidence-based approach to answering to these different societal phenomena during or before crisis or in times of peace. And for that, maybe the one last point that I would make, we see a lot of negligence in platforms' responses, especially in the countries of global majority, where they do not invest into content moderation properly, where they don't have enough content moderators trained in the local languages, or those who would have a proper understanding of national context. And this is the issue that civil society has documented for a decade now, and we still don't see satisfying response. In some countries, in some cases, we see the progress, but we are far from the ideal situation. And here, in order to have that evidence-based approach and in order to really have that causal link between incitement to violence and the real-time, real-life violence, we need access to data. We need to understand what happens on the platforms, and we cannot rely on voluntary disclosure of those data whenever they feel there is too much public pressure on them to actually say something. That also exists, that legal obligation now within the EU, but that can actually help us to understand better how this information spread, how it's being disseminated, who are those bad actors who often stand behind organized disinformation campaigns, and this way we can then tailor adequate responses either at the platform level and have that public scrutiny or at the state level. So very shortly and very quickly, this would be probably the right way to go. And I'm not sure whether I still have time, I probably don't, but maybe one last thing that I would like to mention. Access now runs the digital security helpline that is available 24/7. And we also help journalists. We recently published the investigation on the use of Pegasus spyware against the founder and CEO of Medusa media platform. And we do this investigation in support with our partner. Don't hesitate to reach out. There is someone available 24/7 if you find yourself in a situation where you need help.
Thank you. So our panel, which has covered a lot of things, is looking at legal limitations on media freedom in times of conflict and war. And I think one of the things that's very clear is there are still quite a lot of gaps in our knowledge and understanding, both in the language that is a precursor to conflict and war and how to address it in a way that is proportional and legitimate, that there is perhaps still some limitations around the case law in this, and some challenges for the regulators, I think, in being able to address this in a proportionate and legitimate way. One of the things, I think, from our perspective at the Committee to Protect Journalists is certainly this question around Article 20 and propaganda of war, propaganda for war is an area that I think we could benefit from more research and guidance, and that would help legislators and jurisprudence, in understanding the decisions and clarifying the decisions that states make and indeed platforms make in restricting content. So a lot of work for the Council of Europe as you begin this campaign for the safety of journalists. This is really an important part of the ecosystem. I know it says in your agendas that we'll break at 1:45, but given that I know a number of people have enjoyed the coffee breaks and the time to actually interact with colleagues, we will break now and we'll come back at 11 o'clock. Thank you very much for your attention.